Please be seated.
Good morning, Your Honor. Jamie Fidello of Kirkland & Ellis on behalf of the debtors. We are very pleased to be here today to present the confirmation of the debtors' Chapter 11 plan. I'm joined in the courtroom by my partners, Ryan Bennett and Mike Esser, and my colleagues, Dave Gremlin and Rob Jacobson. While I'm happy to report that there is near global consensus today, we do have one outstanding objection to confirmation that will be going forward. So with Your Honor's indulgence, what I would propose to do is to put up a presentation on our case in chief, then get into the evidence, and then we can get into the arguments on the outstanding objection of Stone Cold. And I had the opportunity to confer with Stone Cold's counsel, and he was good with that approach. Thank you, Your Honor. So if I can put the presentation up, which is already on the screen, happy to dive in. Starting off, I think it is important, Your Honor, to remember where the debtors were in these cases only 2 months ago, at the time of our first interim DIP hearing in mid-January. At that time, the debtors had yet to reach a deal with the creditors committee regarding the settlement of sponsor claims. The Garawan parties continued to object to a number of motions and were not yet supporters of the plan. And the required lenders and agents had essentially declared open war on each other. While we were able to bring the UCC into the fold shortly after that hearing, by the time the voting deadline passed on the original plan in early February, it was obvious we did not have the votes, and that plan failed. But like responsible fiduciaries, we of course did not give up. We resolicited the plan and kept hammering away at the secured lender groups. It came down to the wire, and I'm sure Your Honor has seen the flurry of paper that has been filed. Apologies for the volume, but we are beyond thrilled. Ultimately, the level of consensus here, save for the single remaining objector. Just at a very high level summarizes this slide. At a very high level summarizes the key terms of the plan, but I think what is more important is on the next slide, which is the unanimous voting results. Every single class has voted in favor of the plan. 100% of our funded debt creditors, in fact, voted to accept, and approximately 95% of Class 7A general unsecured creditors. So what does the plan contain? In addition to the orderly wind down of the OPCO debtors and reorganization of PropCo, at bottom there are 3 core settlements contained in the Chapter 11 plan. The first of which is the original settlement with the UCC, the equity sponsor, and McKinsey, which I will refer to as the 9019 settlement. That settlement is incorporated into the plan, and there is a separate 9019 motion, but to the extent the plan is confirmed, that motion can be withdrawn as moot. Effectively, the 9019 settlement provides that the sponsors contribute $2.2 million in cash, the majority of which will be used to fund a GUC trust to distribute assets to general unsecured creditors and administer claims. Certain of the debtors' secured lenders in Class 7B are gifting the recovery on account of their deficiency claims to the GUC trust as well. McKinsey has also agreed to waive their significant unsecured claims against the estates, thereby improving recovery for other unsecured creditors. And finally, there are mutual releases and a waiver of potential avoidance actions. The second settlement is the Garawan settlement, whereby the Garawan parties are contributing an additional $250,000 to the GUC trust. The debtors will agree to cooperate with respect to delivery of certain electronic information, and the Garawan parties have become released parties under the plan. And the last settlement, which I think can say was the hardest settlement to reach, was the inter-lender settlement between the required lenders under the DIP facility, who are slightly more heavily concentrated on the PropCo side of the house, and the agents under the OPCO credit agreements, Rabobank and RBC. The technical modification version of the plan filed at docket number 808 reflects the terms of this inter-lender settlement, and there was also a settlement term sheet filed with the plan supplement. Suffice to say, there were a number of negotiated terms contained in those definitive documents, in addition the highlights presented here, but I think the core economic terms can be summarized as follows. The reorganized PropCo will agree to maintain a collateral coverage ratio that requires reorganized PropCo to have 150% coverage ratio in terms of its assets. And that will protect the value of the $30 million promissory note. The settlement also provides an allocation of repayment obligations with respect to the DIP and the remaining outstanding obligations under the bridge facility, which is set at 80% to PropCo and 20% to OpCo. And the 20% OpCo contribution will have a liquidation preference in the liquidating trust agreement of OpCo. OpCo will also waive any claim it may have to land assets, and PropCo will waive any claim it may have to equipment assets. And upon the effective date, PropCo will pay to OpCo a fixed price per acre for reimbursable cultural costs for acres which are not subject to an early possession agreement and are not under contract for sale. And in terms of the reimbursable cultural costs for acres subject to an EPA early possession agreement or whose sale is closed, OpCo will also receive those reimbursable cultural costs. And finally, on the effective date, the OpCo MSA will be rejected, and OpCo will pay an $8.5 million administrative rent claim to PropCo. So these are the core terms of the interletter settlement contained in the plan. Turning to our actual case in chief, obviously, as I mentioned, we filed a host of documentation. And the plan that I mentioned was filed at docket number 808, and we just filed a revised plan at docket number 841. That was only a few minutes ago, Your Honor, so we're happy to walk that up and walk through the changes. But between 841 and 808, it specifically reflected agreement with two of the objecting parties, Chubb and the 1970 group, with respect to certain insurance provisions, which was not yet finalized at the time we filed docket 808, but now I believe we have a full agreement with those parties. We also filed a proposed form of confirmation order at docket number 840 and had filed previous versions at dockets number 810 and 823. Obviously, we're more than happy to walk Your Honor through those red lines as well to the extent you have any questions. At this point, I would like...
Just so you know, I haven't had a chance to look at any order yet, so that's something that I will have to do.
Absolutely.
I'm looking at the objections.
Understood, Your Honor. So at this point, I would like to submit our declarations in support of confirmation, if that's all right with Your Honor.
Yes.
Thank you. The first declaration is the declaration of John Boken at docket number 821, which addresses the 1129 factors, including feasibility and the best interest test. Mr. Boken is here in the courtroom today, and we would request that his declaration be submitted into evidence.
Is there any objection? I hear none. Mr. Boken's declaration is, I'm sorry. Mr. Miller.
Morning, Your Honor. For the record, Curtis Miller of Morris Nichols Arston Tunnel on behalf of Stone Cold. We entered into a stipulation with the debtors, and it was mentioned earlier, that we are going to be consenting to the admission of the different declarations, and I believe there are 17 different exhibits by the debtors in exchange for some stipulations that will be made on the record by the debtors with respect to administrative rent that's owed to my client and real estate taxes, plus the admission of two documents, my client's lease and the guarantee of that lease. So I just wanted to, as we're starting to go through evidence, I just wanted you to be aware of that.
Thank you.
Thank you, Your Honor.
And I can confirm that as well. We agree with that.
Thank you. Okay, so I hear no objections to Mr. Boken's declaration. That's admitted.
Thank you, Your Honor. The second declaration is from Ryan Sandall from the Houlihan firm, filed at docket 816, which addresses the debtor's marketing process and certain inputs into our liquidation analysis. Mr. Sandall is appearing by Zoom today, but is present to the extent there are any questions. So we would ask that his declaration be submitted as well.
Does anyone object? Hear no one, it's admitted.
Thank you, Your Honor. The third declaration is the declaration from Aaron Schwartz, independent director of the debtors and member of our special committee, which was filed at docket number 817. Mr. Schwartz's declaration addresses the parallel estate claim investigations conducted by K&E and Young Conway, the settlements that led to the creation of the Guck Trust, and Mr. Schwartz's support for the releases contemplated by the plan. Mr. Schwartz is also appearing by Zoom today, but is present to the extent anyone has any questions, and we would ask that Mr. Schwartz's declaration be admitted.
Does anyone object? I hear no one, it's admitted. If someone wants to cross-examine anyone, you need to let me know. You can continue.
Thank you. Your Honor, Mr. Schwartz is traveling internationally, and I think he's had a very difficult time zone situation. So to the extent no one wishes to cross, we request that Mr. Schwartz be able to be excused from the hearing at this time.
Does anyone wish to cross-examine Mr. Schwartz? I hear no one. He may be excused whenever he needs to get off.
Thank you, Your Honor. And the final declarations are the voting reports from Leticia Sanchez of Stretto, our noticing and claims agent, which were filed at docket 819 and docket 838. The reason that we filed an original voting declaration and amended voting declaration in this case is that we extended the voting deadline for certain of our secured lenders, and an unsecured creditor passed the original voting deadline of last Friday as we continued negotiations. Per Your Honor's comments at the supplemental DS hearing, this was plainly disclosed who we extended and through what time in the declarations. And as I mentioned previously, the voting declaration shows an overwhelmingly supportive voting report at each and every box and every class. So with that, Your Honor, and Ms. Sanchez is in the courtroom today, but would ask that the declarations at dockets 819 and 838 be admitted into evidence.
Does anyone object? I hear no one. They're both admitted.
Thank you, Your Honor. And we also filed our brief at docket number 229 that summarizes our case in chief, and I have the 1129 factors up here and the various evidentiary support. Of course, I'm happy to dive into any factor if Your Honor requests, but I did want to highlight a few points. The first is that the only objection to any of the 1129A factors is an 1129A1 objection that the plan complies with all sections of the title. I'll turn to that in a moment when I get to the objection, but that's the only actual contested issue in terms of the 1129 factors. And as set forth in Mr. Boken's declaration, under the plan, each impaired class, each holder of claims or interest will receive as much as they would recover in a hypothetical liquidation. The best interest test is satisfied, set forth in Mr. Boken's declaration. The debtors have received over $100 million in sale proceeds to date, are under contract for an additional $140 million of proceeds. We expect significant cultural cost reimbursements in excess of this amount, and have yet significant land and equipment assets yet to be sold. We submit that the plan is feasible. And finally, wanted to note as to the discretionary provisions of the plan, Mr. Schwartz's declaration set forth the specifics of the investigations conducted to support the settlements incorporated into the plan. Third-party releases are also fully consensual, consistent with the case law in this district. And we, of course, worked with the U.S. trustee to resolve any concerns with the release and exculpation provisions. We believe that the discretionary provisions of the plan are appropriate under the circumstances and should be approved. So that concludes my presentation. I'm happy to address any questions Your Honor has, or I can dive into the outstanding objection. Okay. So as as Stone Cold's counsel mentioned, we will seek to introduce, he will seek to introduce, two exhibits to which the debtors have no objection. But at this time, I would propose that the debtors move exhibits 5 through 17 on our witness and exhibit list into evidence. The first 4 exhibits were the declarations that were previously admitted.
Okay, well, those have already been admitted, so what do you want on your list?
Exhibits 5 through 17. I'm happy to run through as well.
What are these being admitted for? These are all different filings? What are they being admitted for?
These are being admitted for purposes of the objection, but in particular, from the debtor's perspective, exhibits 11 through 17, which are excerpts from our schedules and statements, are particularly cogent to the objection.
Okay. Okay. If there's not any objections, I'll admit them, but you'll need to explain to me why they're relevant to something.
Understood, Your Honor. So turning to the objection, and it's from our landlord, Stone Cold, which is a landlord at a packing facility in California. They raised 2 issues to confirmation in their objection. The first was related to feasibility, which we can resolve. The debtors obviously submit that the plan pays administrative claims in full. To the extent that Stone Cold has an administrative claim, it will be paid in full. And we can represent that the debtors have sufficient assets to pay that administrative claim to the extent it is due and owing. So with that...
Do you have evidence on that?
Yes, Your Honor, that would be contained in Mr. Boken's declaration at docket 821.
Okay.
So the only contested issue in the objection relates to Article 4C of our plan specifically. That provision, which was a term of the 1919 settlement with the UCC, provides that solely for purposes of making distributions to general unsecured creditors from receiving distributions from the Guck Trust, all general unsecured claims are deemed to be claims against Wawona Farmco, LLC. And second, all guarantee claims or claims against multiple debtors are deemed to be a single obligation against Farmco. As I mentioned earlier in my presentation, the distribution to unsecured creditors was a hard-fought settlement, and unfortunately results in a relatively limited pot of cash of $2.45 million. And some of that $2.45 million in cash is earmarked for distribution to certain secured lenders on account of deficiency claims. So the actual pool of assets for general unsecured creditors is quite small in this case. The treatment in Class 7A, including that Guck Trust distribution, was put to all general unsecured creditors, from whom 137 out of the 142 ballots cast voted in favor of the plan. When we formulated the settlement, the debtors and the UCC were faced with the dilemma of divvying up a small pool of settlement proceeds in the most efficient and fair way possible. And we believe that the deemed distribution provisions in the plan are integral to that settlement, and at bottom should be considered a plan treatment issue, which the general unsecured creditors voted to accept. I believe that Stone...
You didn't brief it that way. That's not the response in the memorandum.
Understood, Your Honor. There are subcon issues. We'll get to them, but we do believe that this is an 1123A3 issue and an 1126 issue. The plan...
I don't have any law on that, but okay.
With, just to summarize, 1123A, 1123A3 provides that the plan may obviously treat certain classes of claims, and as part of that treatment in any Chapter 11 plan, for example, it will specify if consideration is in the form of cash or securities or some combination thereof, and it also can set forth mechanics for how creditors receive that distribution. And we think that
Can treatment eliminate somebody's claim?
treatment by itself cannot eliminate someone's claim. However, claim entitlements, there's no entitlement to a claim other than what the Bankruptcy Code provides. The Bankruptcy Code provides that you would need to satisfy that something is in the best interest of creditors. And the schedules and statements show that the claims that Stone Cold alleges are, they're against boxes that have zero assets. And these are empty shells.
That's different issues. You're saying this is a treatment, and I'm asking about treatment and whether treatment can eliminate somebody's claim.
Yes, treatment can eliminate someone's claim. In the
Law says that?
Yeah, 1123 also provides that the plan can deem certain creditors to reject if they receive no recovery. So treatment certainly can eliminate and discharge claims of creditors.
And they have to have some law on that.
Understood. Moving away from the treatment issue, Your Honor, specifically on the subcon point. So I think there's two relevant cases here. The first is Genesis Health, a Third Circuit case, and Owens Corning, also a Third Circuit case. Genesis Health, which was decided a few months before Owens Corning, clearly states that deemed consolidation does not necessarily result in substantive consolidation. And we believe that this is not a substantive consolidation issue. It was put into the plan for administrative convenience. There is a single pot of cash, which is an asset of OPCO in this case. It was recovery on account of preference claims. Stone Cold has a claim against OPCO. We don't dispute that. They have a rejection claim against OPCO. They also have 5 claims against other boxes that are not OPCO, do not have any assets. And so what they're attempting to do is effectively bootstrap those 5 claims into a 6 times recovery against the Guck Trust that will completely swamp the claim pool. I believe the rejection damages claim is in the order of $15 to $20 million. So at a factor of 6, there would be effectively no recovery to other general unsecured creditors. Stone Cold would receive the entire, or almost the entire recovery under the plan from the Guck.
Is that just a function of what the plan provides for?
Well, no, the deemed consolidation provision provides that it does not. That's not the result.
Okay. And how does the Genesis Health case, which I did read, and I have it in front of me so you can point me to it, how does that aid the debtor?
What Genesis Health stands for is the proposition that a deemed consolidation is not automatically substantive consolidation. And this is not substantive consolidation here because there's a single asset which belongs to a single debtor.
But the plan provides that all general unsecured claims against all the debtors shall be deemed general unsecured claims against debtor Wawona Farm Company, LLC.
It does appear facially to look like a subcon provision. We don't dispute that. But that doesn't mean it's substantive consolidation because
the Genesis facts are totally, wholly different than these facts, right?
In that case, yes, the debtors were actually arguing in favor of subcons to avoid U.S. trustee fees.
Right.
So the facts were different.
And nobody objected to that provision at confirmation or suggested that whether it was appropriate or not. This is an after the fact, taking a look at what the debtor did and saying that provision for purposes of payment of U.S. trustee fees doesn't do a subcon.
I agree with that, Your Honor, but I would also submit that the facts in Owen Corning are quite different. In that case, there was a $2 billion loan from lenders I think it was something like 55 debtors, and the debtors respectively proposed to eliminate that structural seniority entirely, and significantly disadvantage those lenders and upend the world of secured lending, as the court noted, or unsecured lending in that case, as the court noted in Owen Corning. Here, Stone Cold has a claim against OPCO, which is an operating entity with assets and liabilities, and it has 5 claims against empty shell entities. And if their argument is correct, they would, no unsecured creditor effectively would get on any recovery, which the unsecured creditors voted to accept. So we don't think that's an equitable result in any way whatsoever, nor is it supported by the law.
I mean, what's the standard? What's the standard I'm looking at in terms of this provision in the plan?
Well, the debtor's position is that this is an 1123A3 and 1126 issue, but if Your Honor, does...
I don't know that it is or it isn't.
If Your Honor doesn't accept that contention, I think the standard would be Owen Corning, which provides that there can be consent to substantive consolidation. And the class, 7A, voted to accept this provision. Stone Cold didn't vote, but they had every opportunity to do so. They knew they had a potential rejection damages claim. They could have appeared at the disclosure statement hearing and objected to the solicitation procedures. They could have filed a 3018 moment to estimate their claim for voting purposes. They did none of that. Now they're appearing at...
The debtor could have done stuff too, and the debtor didn't. The debtor could have objected to claims. The debtor could ask for estimation. The debtor could do this or could have a different provision.
That is fair, but the solicitation procedures provided that we sent the claims to folks that had filed proofs of claims or were scheduled. We didn't send ballots to potential unsecured creditors who had a rejection damages claim. Stone Cold was on notice that the contract would have been rejected. So if they had wanted to vote on the plan, certainly they'd have every opportunity to do so.
And what would their vote on the plan have done?
Well, I think I can't speculate to them, but their vote on the plan could have resulted in certain unsecured classes at some debtors voting to reject the plan, and then that would have implicated the death trap provisions, reducing the pool. I don't think they likely would have done that, but I don't know.
Okay. But Owens Corning says you can consent to subcom, but the debtor is saying this isn't subcom. So how does that case apply?
Well, we don't believe it's subcon. I know I've said that, but to the extent it is, Owen Corning's applies.
I know that it is subcom. Might be treatment. I didn't brief it that way. So the debtor, how can the debtor rely on Owens Corning and consent to subcon if the debtor is taking the position this isn't subcon?
I'm arguing in the alternative, respectfully. So for the sake of argument, if it is subcon, Owens Corning would apply, and Owens Corning states that subcon can be accomplished through consent, and we believe that Class 7A has consented to this treatment, and it should be bound on all creditors.
Can I have a second?
Yes, if Your Honor is okay.
I kind of look at this consolidation issue as somewhat moot, given other issues within the plan. Whether these are consolidated or not, if you treated these as non-consolidated, isn't the only issue at this point, since the classes carry whether they're consolidated or not consolidated, whether they're getting at least as much as they would in a liquidation?
I don't know, but again, that hasn't been briefed for me. I spent time with these objections last night to try to understand all the outstanding objections. There's one outstanding to let Mr. Miller make his case, but it was briefed to me the way it was briefed to me.
Your Honor, let me see if I can try and cast a little light on this from the unsecured creditor's perspective. Andrew Bellman from Lowenstein on behalf of the committee. I think to Mr. Fidel's final point, it doesn't really matter if it's subcon or not, because Class 7A consented to whatever Class 7A is. Whether you call it treatment and say Class 7A voted to accept, so
That's
clearly.
my question. Can, as part of treatment, a class eliminate somebody's claim? I don't know that that's treatment.
Let me pose a hypothetical, which I think is where Mr. Siegel was hinting that may help. The goal of this provision was simply administrative convenience, with the expectation that if somebody filed a claim against the wrong debtor, somebody thought they were doing business with one of the other Wawona entities. These things have confusing names. Somebody files a claim against the wrong entity. All of the unsecured claims are at OPCO, other than these 5 sort of inchoate landlord claims that we'll talk about in a second. But all of the unsecured claims are expected to be at OPCO. And the anticipation was, like any other case, we probably would have some slug of unsecured creditors that might file claims against the wrong debtor. It wouldn't matter. They have a claim against OPCO deemed under the plan. They're deemed to only have one claim. They get their distribution. They go home. There's not a lot of money in this case for unsecured creditors. It's a nice recovery in the context of the case, frankly. But it's a very small sum in the context of the capital structure of this debtor and the debt load that we're looking at. If the plan were written differently, and I understand that Your Honor may tell me that it's not, but if the plan were written differently, frankly, I think Your Honor probably has the pen to make this happen.
No, I don't. My plan, I can confirm or not confirm.
So if the plan were written differently, and you just had, I don't remember how many debtors there are, we'll say 8 or 9 Class 7As. You had 7A 1 through whatever, 1 for each debtor. There is no dispute that at each of these 5 boxes, other than OPCO, where Stone Cold asserts claims, they would get nothing. They would get 0. There are no assets there. There's nothing to distribute to them there. It's not like we're substantively consolidating and taking away valuable claims that they would otherwise have. We're simply providing the same result that they would have gotten in a separate, messier plan with 8, 9, 10 different Class 7As. What they're trying to do now, as Mr. Fidel very artfully put, is multiply their claim by a factor of 6 and swamp the unsecured creditor class and take the whole distribution for themselves. To my hypothetical, though, and I hope I'm not speaking out of school with respect to the debtors or lenders, I don't think it would be that big of a deal if the debtors simply did rewrite the plan to say, okay, fine, there's 8, 9, 10 different Class 7As. All of these are getting nothing, and they're deemed to reject. There would be no impact from that. They would be deemed to reject. Your Honor would still be looking, at the best interest test based on Mr. Boken's declaration. Those folks are all getting more under this plan than they would in a hypothetical Chapter 7.
It's not what the class voted on. They voted on this plan, not some other plan.
Sure, but nobody would be affected at any other debtor than OPCO.
I don't know that. How do I know that? Other than counsel's representations of what's in each class, I have no idea what the claims pool is against each of these debtors.
Okay. I think those are all things Your Honor can see from the record. Perhaps there would be some supplemental briefing needed on that, but I think that's something that could be done. I don't think it needs to be done. I think it would be a waste of effort for the debtor to have to do that. I think there's a very simple path, which is to find Class 7A consented to whatever the plan says Class 7A gets, and that's it. That's the end of the discussion. But if need be, there are alternatives, but those alternatives all get you back to the exact same place, which, frankly, is why the plan was written the way it was and why, presumably, Class 7A voted to accept.
Convenience. What I'm struggling with is whether administrative convenience can eliminate somebody's claims.
Understood. And, Your Honor, our position is where those claims are intrinsically worthless, it can and it should. Thank you.
Mr. Miller.
It's always fun to be the only person objecting to a plan.
In there.
Yeah, I know. So I guess, I'll respond to the comments from everyone on both sides of the courtroom in a minute. But I guess where I wanted to start was with respect to the evidentiary record.
Yes.
Could I please hand up copies of the lease and the guarantee?
Please. I understand there are no objections.
Sorry, Your Honor, that's correct.
So the lease would be Exhibit 1 and the guarantee Exhibit 2? Sorry, for the record, the lease would be Exhibit 1 and the guarantee would be Exhibit 2.
Okay,
Let me just distribute copies real quickly.
thank you. And they're both admitted.
Thank you, Your Honor. Second, with respect to the stipulation, which I appreciate from debtors' counsel, we made a feasibility objection. And the debtors stated that there would be sufficient cash to pay administrative rent and real estate taxes that's owed to my client. I just wanted to specify the amounts for the record. So for the March 1 quarterly rent, which came due during, obviously, the post-petition pre-confirmation period, it was $1,342,748. And the prorated taxes are $290,575. And the representation is that there would be sufficient cash to pay those amounts. If I could ask debtors' counsel to confirm those specific amounts.
Yes, that's okay. Thank you.
Thank you.
Thank you. Okay, so why don't I start by just addressing some of the later points, and then I'll get into my presentation, because I think those are the issues that Your Honor, I think, is correctly focused on. First, with respect to this concept of Stone Cold having consented to this treatment under the plan, we obviously did not. We objected to confirmation. We did not vote in favor of the plan. And as you mentioned, there's nothing briefed in the confirmation memorandum that says simply because a class votes in favor of a plan that eliminates the ability of a creditor to object to substantive consolidation. 1123.
And I don't remember Owens Corning, but was the consent in Owens Corning, I remember you can do it by consent, but did they address what consent is, and could it be done by class, or is it all creditors?
Owens Corning does not address specifically class consent,
Right.
but what it does very specifically say is that if a creditor is adversely impacted by consolidation, they have the right to object. That's what we're doing, Your Honor. So regardless of what Class 7A did, and again, that's the way they set up their plan, we're just coming to the court with the claims that we have. We have, as you'll see in the leases, in the lease and in the guarantee, we have a lease against 5 debtors, and we have a guarantee against a 6th debtor. They're all jointly and severally liable for all obligations under the lease. These are the state and contract law rights that we have. All we're doing is coming to the court under the plan that they've proposed and said, here are our claims. We haven't even filed claims yet because the debtors are still in our property. But here are our claims, and when you do start paying out money under this settlement plan construct, we are part of that creditor body that's going to receive payment on our claims. That's all that we're doing. We're not coming in here, trying to, in some nefarious way, sneak our way in and take more money from the estate. We have the rights that we have, and we're just presenting those under the plan construct that's been put before Your Honor. So with respect to consent, Your Honor, we don't think there's any way that we actually consented. With respect to administrative convenience, we see that all the time. I put in my plans all the time, substantive consolidation, deemed consolidation, solely for administrative purposes. It's one thing if no one's objecting and isn't having their claims eliminated. It's another thing entirely if, exactly like under Owens Corning, the Third Circuit decision, which Your Honor is compelled to follow, they are trying to eliminate claims. Owens Corning, the debtor tried to eliminate a guarantee claim of a lender. The Third Circuit said you can't use substantive consolidation in that way unless you satisfy one of 2 tests, neither of which the debtors have put on any evidence or even tried to say that they can satisfy, because their statements to Your Honor are they are not substantively consolidating the estates. And Your Honor, I think it's important, and if you actually look at page 77 of the plan, Article 7D, it actually states, and this is, let me find the provision because I have lots of documents up here. The section is titled Adjustment to Claims or Interests Without Objection. It's in the latest version of the plan that I had before the one that was filed today. But what it states is any duplicate claim or interest or any claim or interest that has been paid, satisfied, amended, or superseded, and then in parens, whether by virtue of substantive consolidation of Class 7A general unsecured claims provided for under the plan settlements, this plan, or otherwise. They're very clearly trying to substantively consolidate all claims in Class 7A. With respect to their statement, the committee's statement, that if they had come to you with a different plan, the result would be different, it very well may be, Your Honor. But what we are doing is coming to you under the plan that was filed, solicited, went out for vote, and they're trying to present for confirmation today. We're just coming with the rights that we had, as I already said, and that's the plan that's before Your Honor. If they want to go back, change that plan, we'll take a look at it. They can resolicit it. We'll decide if we want to object or not. But that's the plan that's before Your Honor, not some hypothetical plan that doesn't currently exist. Also, with respect to this whole, argument of these boxes of different debtors have no assets, look at the presentation that the debtors made at the beginning of this hearing, and look at the settlement that's put forth under the plan. What it has is consideration flowing from each of the different debtors to the settling parties. They're giving releases to the sponsor, they're giving releases to the Garowin parties, and in exchange, this $2 million or $2.2 million payment is coming from the sponsors, and the $250,000 payment is coming from Garowin. That's where the consideration is flowing in both ways. And then what they're trying to do is say that, well, nothing should be in these other boxes because there's nothing there. But if those debtors who allegedly have nothing are giving consideration as part of this settlement,
Being
the releases. It's more than the releases, but the releases, I think, are probably the biggest one for the sponsor and the Garowin parties. There are other items, but the concept is if there's consideration flowing from the debtors to the settling parties, it's not coming from just one of the debtors. It's coming from all of the debtors. And that's the way they structured this settlement. I understand why they want releases from all of the debtors, but clearly that's consideration coming from all of them. And so, Your Honor, just to get into my presentation, so the debtors that are jointly and severally liable on the lease are Wawona Packing Company, LLC, Garowin Supply, Inc., Garowin Farming, LLC, Garowin Farming Services, GFP, LLC, and Garowin Farming Partners, LLC. As mentioned, they are jointly and severally liable under the lease. The lease is separately guaranteed by MVK Intermediate Holdings, LLC. So, Your Honor, my client has no wish to prevent confirmation of the plan or preclude a reasonable settlement, but the plan that's presented to Your Honor significantly prejudices my client by trying to eliminate 5 of its 6 claims. You heard debtors' counsel say that just one of our rejection damages claim is going to be approximately $20 million. So we have 6 of those. It's a $120 million claim. They're trying to eliminate $100 million of my client's claims in this case.
Well, is it 120 million, or is it 6 claims for 20 million, and then when you get 20 million,
That's right. I stated it incorrectly.
Okay.
We can't get more than one satisfaction, but under the plan, the settlement consideration as it exists, that'll never happen. So you're correct. But the point is that whatever that distribution is, they're trying to eliminate 5/6 of it.
Okay, well, and it doesn't matter that if, in fact, I looked at each of these debtors, some of them have 0 assets or 0, at least according, I guess, to the liquidation analysis, if I remember them correctly.
I don't think that it does, Your Honor, because that's not the way the plan is set up. The way the plan is set up is 7A gets this distribution or gets this pot of cash. So it's going to be about $2.45 million. And all creditors in Class 7A, which is the consolidated voting class, get to share pro rata. That's the way the plan is set up. We're just coming to the court with the state court and the contract rights that we have, and they're trying to eliminate them. So also, Your Honor, and we'll get to this in more detail, but if you look at section, it's Roman numeral 4C of the plan, they actually title that section Deemed Consolidation of Class 7A. And that's really important under the Owens-Corning decision. So this deemed consolidation, and that is exactly what the Third Circuit dealt with in Owens Corning. The Third Circuit held very clearly that a deemed consolidation is not permitted when it adversely affects non-consenting creditors. Here it's unquestionable that eliminating 5 of my clients' 6 claims would be adversely impacting them.
When I'm looking at that inverse impact, am I allowed to look at the fact that not all debtors have assets?
Your Honor, that is not the way Owens Corning is set up, and that's not the way the analysis is set up. The way that it's set up is, does a consolidation, in that case a deemed consolidation, just like here, does that have the impact of adversely affecting a creditor's claim? There was a guarantee. Here it's a guarantee. We have a guarantee, and they're trying to eliminate that guarantee. We also have other claims, but they're trying to eliminate our guarantee, just like the Third Circuit said the court can't do. So the motion that was before Owens Corning and the Third Circuit, that was the Third Circuit reversed that motion to approve a deemed consolidation. As I mentioned, it eliminated guarantees held by a lender. In Owens, they were separate debtors, and that had separate purposes. And here, and I forget if there was one actually stipulation that we forgot to put on the record, and I'll have the debtors confirm that, is that the debtors here did treat each of their entities separately. They filed separate MORs. They filed separate schedules and statements for each debtor. So it's very clear these were different entities. They had different purposes. Here, one, as Your Honor is well aware, one debtor owned the property, one debtor owned the equipment, and that was the way that they operated. So they were set up as legally separate entities and distinct entities. But in Owens, the debtor, through their motion, tried to eliminate guarantees through their motion for a deemed consolidation. The Third Circuit called that remedy rough justice, said it should be extremely rare and could only be approved in 2 circumstances if it adversely impacted a creditor that did not consent. One is that pre-petition the debtors disregarded separateness so significantly that their creditors relied on the breakdown of entity borders and treated them as one. We know that didn't exist here because we had schedules and statements filed by separate debtors. Or 2, post-petition, their assets and liabilities are so scrambled that separating them is prohibitive and hurts all creditors. Again, debtors filing separate MORs for each debtor. And in addition to that, they went out to all of the different debtors' creditors and had them vote. So by debtor. If you look at the voting report, the voting is recorded by debtor. So clearly, separating them is not going to cause this great harm where it would eat up all the costs of the estate. And the debtors who have the burden under Owens Corning, they have not made any effort to prove that either of those circumstances exist. They say we're not trying to subcon. Let's talk about also one item that the Debtors Council said was that there's no other provision of the bankruptcy code that's being said is being violated by their plan. That's just not accurate, Your Honor. If you look at the objection that we filed, we also objected, in addition to substantive consolidation, to 1123A4. And that's in paragraph 22 of our objection. And that is because the plan provides different treatment for claims of a particular class. So here, if you're a creditor that has only one claim, you get X distribution on all of your claims. It's just one. But if you have more than one claim, your extra claims, any claim more than one, gets eliminated. That is very plainly different treatment to similar creditors in Class 7A, and that is where we sit, Your Honor.
Yeah, I wasn't quite as sure about that. The only cases I could think about in that context weren't really this type of case, where someone tries to argue, what's that case out of the D.C. Circuit? In any event, I don't know about that argument, but I did read it.
Okay. Your Honor, my point is we raised it. It's in addition to our Owens Corning objection, but we did object to the de facto substantive consolidation of Class 7A. So let's talk about the debtor's response to our objection, specifically what's in their confirmation memorandum, and then I'll touch on the other points that they raised. First, they say the plan expressly states no subcon is occurring, so Your Honor doesn't need to worry about Owens Corning. Obviously, that's a form over substance, And in addition, as I mentioned, if you look at page 77 of the plan, Article 7D, the debtor actually admits they're trying to substantively consolidate all claims in Class 7A. And as to 1123A4, the debtors don't respond at all. So, Your Honor, I think that argument is waived. But let's look at what the plan actually says. So if you look at page 44 of the plan, and it's the section titled Deemed Consolidation of Class 7A. It's really clear, and actually the language just puts it squarely within Owens Corning when they call it the deemed consolidation. But if you look at subpart B, it states all guarantees or responsibility of one debtor for the obligations of any other shall be deemed eliminated. And then subpart C, solely for the purposes of distribution from the Guck Trust and no other purpose, each general unsecured claim filed or to be filed in the Chapter 11 case of any debtor shall be deemed filed against and shall be a single obligation of Wawona Farmco with respect to any distribution from the Guck Trust. That's precisely the type of treatment that the Third Circuit in Owens Corning said is impermissible, without satisfying either of the one of two tests that the Owens Corning said is okay.
Or consent.
Or consent. But we clearly have not consented, Your Honor. Next, with respect to Genesis Health, you had some colloquy back and forth on that. I actually think it's a little puzzling that they cited to it because I think it actually supports my position. You know, there, the debtor tried to, even though they had deemed consolidation in their plan, they tried to say, well, we don't have to pay U.S. trustee fees for all of the debtors. And the U.S. trustee said no. Went to the district court said, sorry, debtor, you lose. Went to the Third Circuit affirmed. And this was Judge Ambrose before he wrote Owens Corning. It was only a couple months before, but it was right before he wrote Owens Corning. Clearly had this issue on his mind. And when you go back and you actually read Owens Corning, at page 216, Judge Ambrose cites Genesis for the proposition that a deemed consolidation, and I'll quote, fails even to qualify for consideration. And then the next argument the debtor makes, and they're, Mr. Siegel?
Is there a reason you're standing, Mr. Siegel?
I only would like to suggest, subject to Toronto's calendar today, that perhaps a break of some period of time might be constructive.
Well, you're going to get a break, but I'm going to let Mr. Miller finish his argument.
No, that's fine. I just thought
You're going to get a break because, as everyone knows, this time was scheduled for a non-opposed hearing. There were not supposed to be any objections remaining, so I don't have all day for this hearing. But Mr. Miller's going to get to continue.
No, and I fully understand. I just thought it might be.
It's going to be soon because I have a commitment.
Yes, we understand.
Mr. Miller.
Thank you, Your Honor. Next, with respect to the argument that Your Honor should approve it over our objection because it's fair, and we are being inequitable, as I already mentioned, we're just coming with the rights that we have. The debtor signed that contract. The debtor signed the guarantee. It's not inequitable for us in bankruptcy to assert our contractual rights. It's just not. That's why anyone has a claim. There's nothing that says that the court can just go ahead and eliminate claims held by a party simply because the committee says and the debtor says it would be unfair to others. We have the rights that we have. The fact that we have...
That's why I asked if it was treatment. That's why I'm trying to understand how that could be treatment. And maybe it can be, but it wasn't briefed that way.
I mean, I didn't look at it because it wasn't briefed, but I've never seen any case say that treatment under 1123 means that it can eliminate all the rights of any creditor, because otherwise every plan that I ever file as a debtor would be much easier, Your Honor. Obviously, we can't do that. So in sum, Your Honor, the Owens Corning decision in 1123A4 require that the deemed consolidation be denied. Just let me take a quick look at my notes to see if I missed anything. That's all that I have, Your Honor. Thank you, unless you have any questions.
No, thank you. Happy to hear a response, and we will be taking a break shortly.
Your Honor, understood, and I'll be extremely brief. Just want to respond
Yes.
to a few points. So I think it's clear on the definition of consent under Owens Corning. I don't believe that Owens Corning or any case, I'm not aware of any, maybe Stone Cold is, but actually gets into what consent means under the subcon factors and if a class can consent or if this is an individual creditor right. But
Don't know.
I would look to the code, Your Honor, and there's, of course, certain rights that can be waived by a class. Obviously, the absolute priority rule can be waived if a class consents, and unfair discrimination can also be waived on a class-by-class basis. And, of course, creditors have individual rights like the best interest test and equal treatment. But under 1123A4, I do think it's clear that equal treatment under Third Circuit law, I'm specifically referring to the EFH case. That side is Federal Appendix 638, Federal Appendix 277.
Give that to me again. 638.
638, Federal Appendix 277, that equal treatment does not guarantee equal consideration. So I think
That's not a precedential case, though, because it's in Federal Appendix.
that's correct. It's, I would say, guidance as to, but it is citing.
And what's the fact pattern there?
It was referring to the application to certain MACOL claims that had, I don't have the exact factual reference, but it was a provision in a plan settlement in the a pre-plan settlement in the 1919 context with regards to the treatment of MACOL claims that benefited certain creditors over another that held the MACOL claims. And in that case, the guidance from the Third Circuit was that that was fine in that situation, and it does not, if the provisions are applied equally as to every creditor, which this deemed consolidation provision does apply to every creditor, it obviously would have different results based on which creditor holds a claim at certain boxes, but that does not per se mean that something is unequal treatment outside the realm of 1123A4. So it's...
I don't know. I haven't read those cases, and if you're going to make me read a Sanchi case that's 100 pages to understand something, then that's going to take me some time.
Point well taken, Your Honor. But the point I was making is that there are certainly certain rights that can be waived on a class-by-class basis.
There could be, but I don't know if this is one of them. I just don't know. It strikes me it shouldn't be, but I don't know.
Understood. And I don't think we have guidance from the case law on this issue, unfortunately. But we do know that...
Did anybody look for it?
Yes, certainly, Your Honor.
Okay. So it doesn't exist. Okay?
I can't make a
So it's a matter of first impression that I'm deciding on no briefing.
And the only other points I quickly want to make is that Stone Cold, I believe, is consenting to the fact that these 5 other boxes that they have a claim at do not have any assets.
I didn't hear that consent at all. I heard them say that, in fact, they're giving some consideration, so maybe there is something there. I did not hear that at all.
Okay. And then the last point I would like to make is Your Honor asked if you can consider the impact on other unsecured creditors, because if Stone Cold did prevail and they had 6 claims, around $100 million up to the $20 million recovery, which they would never get to that level. So, 80, 90%, I don't have a number, but I think we can all agree would be a very significant amount of that claims pool would go to Stone Cold.
Yes.
Owens Corning, in any case, on substantive consolidation makes clear that this is a doctrine of equity. So I do think it would at least be appropriate to consider the impact on the other unsecured creditors.
But the debtor's saying this isn't subcon.
If it were subcon, we do say that it is a treatment issue and not a subcon issue. However, if Your Honor disagreed and said that it's a subcon issue, I think it would be appropriate to consider the impact on the other unsecured creditors.
Okay.
Thank
Thank
you, Your
you.
Honor.
Mr. Miller, you have a quick
Very
retort
quickly,
there?
Your Honor. Apologies for standing up here for so long. Just the last point about considering the impact on other unsecured creditors. Your Honor, my client has a huge claim. It's already being capped under 502b6 at $20 million. So that tells you how big our claims are. And then we're only going to be able to share in this small pot. And then they're trying to eliminate 5 of our 6 claims. You know, it's just not equitable. We have a huge loss. And like I said, we're just coming with the rights that we have. We're not doing anything untoward. We just read the plan that was filed with the court and noticed that something is being done that's not permitted under Third Circuit law. Thank you, Your Honor.
Thank you. Okay, well, this is a good time for a break. I do have a commitment. I'm going to have to read Owen's Corning. I don't know if I have to read EFH. I'm going to let the parties talk in the meantime. We will reconvene at 2. I have a hearing at 3. Not a lengthy one, but I do have one. We're in recess.
Probably should have said, well, not really ready. Oh, well. I don't know, because I don't, but I assume so. But as part of the assignment, can we confirm that it says what I think it says, which sounds.
And what you think it says is that the Caltrans basically can administer a claims reconciliation process. I think prosecute and resolve objections to.
Yeah, yeah, okay. That sounds good. Thank you.
And that's got to go to the second.
Legal pad. Recurring theme. All right, I'll just move this to her.
Please be seated.
Hi, Judge. Ryan Bennett on behalf of the debtors. I think folks are still trickling in here. All right. Do we have enough? All right, I'll just get started here, Judge.
Mr. Miller?
No, he's not here. That's a good call. I did just leave him.
Let's find him.
Just need courtesy.
Yep. Ron.
Mr. Bennett.
All right. All right, Your Honor, Ryan Bennett again, on behalf of the debtors. Your Honor, thanks for the time. Ended up being a productive use for everyone. We've come to terms of a settlement of Stone Cold's plan objection and the lease rejection order that will be associated with their claims. Your Honor, the terms of those of that resolution, which we will build into the confirmation order, are as follows, and this is agreed to between the creditors committee and the rec lenders who were part of that fruitful negotiation. It'll be a one-time $800,000 cash distribution from the Guck Trust to Stone Cold, and one $5 million allowed general unsecured claim in the recovery class. So that would be that is in consideration of settling their claim amount objection. The debtors and the rec lenders further agreed to payment of the March administrative claim rent that's due on the leased property, and payment of the prorated real estate taxes as well, and that payment would come out within the next week. It was already in our budget, just the administrative timing. The parties, including the rec lenders, the Guck trustee, and the debtors, reserve all their rights with respect to any remaining administrative claim associated with the lease. Likewise, so does Stone Cold, and that'll be an issue to be adjudicated in the future, or agreed to in the future. And then finally, the parties agreed to a representation from the rec lenders council with respect to lien release associated with the leased property, and I'll let rec lenders council make that representation themselves.
Good afternoon, Your Honor. Luis Juberis with Moore & Van Allen on behalf of 4 of the farm credit banks that, along with MetLife and a host of other unrepresented farm credit banks, constitute the required lenders in this matter. As counsel just identified, the required lenders, and I would stipulate on behalf of my clients, and Mr. Siegel can certainly confirm the same on behalf of MetLife, that the required lenders will instruct the bridge agent and the OPCO agent to not assert liens on, and in fact release their liens on, any immovable personal property or fixtures located on the leased premises. And this would not affect any rights to assert liens on movable property. And we would ultimately work to make sure that the appropriate estoppel certificate or whatever is necessary has the right legal description of the things that we're agreeing on, but the concept is immovable personal property. The liens would be released on that. Thank you, Your Honor.
Thank you.
And Judge, that sums up the settlement, and I can yield the podium back to my colleagues unless Your Honor has questions on the
Let me
settlement.
hear from Mr. Miller.
Yes,
Thank
please.
you.
Your Honor, thank you again for your time. We very much appreciate it. Just a couple points which I think everyone, I think we're in agreement with this, is first, I need final sign-off from my client. I believe this is within the parameters of which I can resolve this, but I do need final sign-off. I don't have that, and I wanted to be straightforward with the court. With respect to the admin rent, our rent, as I mentioned before, it's quarterly rent. So what they're going to pay immediately is going to be the real estate taxes that are prorated, plus the March portion of that quarterly rent. And then we're going to deal with the remaining 2 pieces down the road, whether it's by a motion for payment of an administrative claim or some other vehicle that we'll agree to put before Your Honor. I would expect we'll do that relatively quickly, but I need to talk to my client. With respect to the RBC piece and the rec lender representation that you just heard. I'm in agreement with their representation of, the fixed assets they're going to leave behind. These are like the fruit processing lines, is my understanding. But with respect to removable property, if they think there's value, they may come back and take that. And that was within our agreement. But just so you're aware, this is in the broader context of the rejection of my client's lease. The debtors are still in our property, but this agreement is obviously to have that lease rejected by Monday. So, we have a few days left in this week. The idea would be we'll use that time to come to an agreed upon order on rejection that will allow us to move forward with the property. And I believe that is it. And like I said, I just need confirmation from my client. I don't know how you would like that to be communicated to you, or if I get that confirmation that we don't need to say anything to you. However best you.
Well, we'll figure that out. I still, as I said, I have to review the form of order, so we have some time.
Okay.
That will hopefully be enough for you to get the sign off from your client.
Thank you, Your Honor.
Okay, thank you. Just want to make sure I understand the terms of this. So out of the 2.545, right? 2.45 million in the GUC that's going to the GUC trust. 800,000 of that is going to Stone Cold.
That's correct, Judge.
So that reduces the GUC trust by $800,000. And then, as against that net amount, Stone Cold has a $5 million general unsecured claim that would share with everyone else in the remainder of that.
That's correct. It'd go in the denominator. That's right.
Okay.
Judge, it looks like.
Your Honor?
Yes.
Hi, Your Honor. I apologize. This is Genevieve Weiner with Sidley Austin. I was wondering if I could be heard briefly, even though I'm remote here.
Yes, Ms. Weiner, who do you represent?
Thank you. I represent RBC.
Okay.
And I just wanted to clarify, as there were a couple of comments made with respect to the lease rejection, and in particular, reference to the estoppel certificate that's for the benefit of RBC. So I agree with the parties that we RBC are not interested in maintaining liens on property that the debtors have determined will be abandoned. And we anticipate negotiating a consensual form of order. I don't think, though, that we have yet that consensual form of order on the lease rejection. And so I just wanted to make it clear for the record that we're reserving our rights to comment on the order, including the list of abandoned and excluded property.
Okay. Thank you.
Thank you.
Anyone else who wishes to be heard with respect to the resolution that's been reached with Stone Cold? Okay.
Your Honor, Jamie Fidel of Kirkland Lusigan on behalf of the debtors. You had mentioned that you would like to review the form of order. It was filed at docket 840. I'm certainly happy to address any questions that Your Honor may have.
I haven't reviewed it. So
understood.
I have no questions at the moment. I need time to review it. Is there, I guess I want to make certain, do we have any other issues to be raised and addressed for confirmation other than the form of order and Mr. Miller's need to confirm that he has sign off from his client?
Judge, subject to obviously anyone else who wishes to make an appearance, the debtors believe that the revised plan that was filed at docket 841 obviously didn't address Mr. Miller's concern, but did address the issues of all other parties, and also the confirmation order filed at docket number 840 included agreed upon resolutions with every other objection that was filed.
Okay, and is there new Is there language in the newest form of order that addresses the Chubb and 1970 objections?
That is correct. In both the plan at 841 and nothing in the confirmation order. So it was solely in the plan at docket number 841. And we're happy to pass, Your Honor, the specific red lines to which would.
Can I see what that is? Yes.
Yes.
Thank you. Hi.
I'm just, in case you need me.
Okay, where am I looking?
If you give me a minute, at the end of the definitions, 240, 241, and 242, we have three new definitions. That's on page 25 of the red line. Those relate to a new administrative claim reserve that we're putting in place, earmarked specifically for workers' comp claimants that have allowed administrative claims. And it's not a cap on their claim amount, it's just funds earmarked for them. And then that's obviously addressed later in the plan. Would you like me to guide you to the next revisions?
Yes.
Next I go to, apologies, I'm flipping page by page just to make sure I don't miss anything. Next I go to, I think it's Article 4F, Workers' Comp Administrative Claims Reserve. That's on page 55 of the red line and runs over to page 56, which provides for what I just described with respect to the new defined terms. One thing I had neglected to mention, that in addition to not being a cap, if not all of the funds are used, they do, at a point when the liquidating trustee determines that all other liquidating trust assets have been liquidated, then these can also be distributed to the extent there are any left to other creditors consistent with the plan and the agreement.
Okay.
Next, we move to, I apologize again, going page by page, assumption and rejection of executory contracts and unexpired leases. We have provided just that insurance contracts are not automatically rejected by virtue of not having been listed outside of this. This provision generally provides for automatic rejection if not specifically noted otherwise. We are not committing to assume them all at this point. There are, a few that we need to look at, but we are just providing that they're not automatically rejected by virtue of not being listed somewhere else yet.
So is that to resolve the two objections, or is that a more general provision?
It was in part to resolve the two objections. We spoke with each of the objectors, and in particular, we thought it was an appropriate way to address Chubb for now.
Okay.
And if you, on page 72 of the red line, insurance contracts, I apologize, I'm not quite sure what the article citation is.
I found you. I'm there.
I'm happy to address any of this if you think it's helpful. Obviously, some of these are just cleanup line edits or clarifying edits. And the revisions to this provision, I just want to flag for you, run on to the next page as well.
guess I'm a little confused. If all of the contracts are revesting, all the insurance contracts shall revest and either reorganize Propco or the wind-down debtors, then how does that work with the first provision that everything isn't yet assumed?
So,
Or yet rejected if they're revesting?
so, and this relates to the revision on the next page, the concern that we were trying to address with Chubb, their legacy workers' comp provider. They were concerned that if they are not able to say that the insurance policies have vested with the go-forward entities, that they won't be able to try to, get what they can consistent with the plan on account of anything that comes due. And,
I understand
and so
that.
they wanted to be able to trace through to the new entities, I think in part to help administer their program generally. And then we included the proviso at the end with our other constituents in mind that just says your contract is revesting, and notwithstanding that you are not getting a priority claim that you're not otherwise entitled to.
Okay, this is agreed upon language.
This is agreed upon language between us and Chubb in particular in this provision.
Okay, I'm hoping nobody's going to ask me to interpret it. Okay.
And just while I'm here, the 1970s group, they asked me to note two things. Their objection largely addressed arguments related to administrative claims that they believe that they have, tabling that for another day. They're fully resolved. They agree that it should not and is not so relevant to confirmation of the plan. And they wanted to specifically note our confirmation order, I think, is consistent with this, but that on those issues, their objection is not overruled and their objection is resolved.
Okay. Anyone else?
Your Honor, for the record, Curtis Miller, Morris Nichols, Arston Tunnel. Just one question. Based on the comments from RBC's counsel, they obviously feel like they need some more diligence to complete. If we don't have, Friday is obviously the court is closed. It's an issue for us to have the lease rejected by Monday. Do you have any time tomorrow afternoon in case there's any open issues?
We're going to meet tomorrow because we're going to need to discuss the order tomorrow. If I have any issues, I'm going to have to review it tonight.
Okay.
So,
Obviously, our hope is that we have no issues on the lease rejection
Of
order,
course.
but just in case.
I forgot what Ms. Johnson told me. I need to take a moment and double check with her on a particular matter. So, we're going to be in recess for a moment while I get my calendar straightened out.
Thank you, Your Honor.
Okay, we'll be back here tomorrow at 2. Parties who really don't anticipate say anything can be by Zoom. So not everybody has to be back here tomorrow. Okay? If you really think you're going to need to discuss the order with me, it's probably best if you're in the courtroom. Any questions? Okay, then we are adjourned until tomorrow at 2. Oh, there's a
Apologies all around.
Do we have other stuff on the agenda?
On the agenda, we
Ah.
have one sale order, which we filed a COC for, and a declaration from Mr. Sandall. And the only reason that I would like to handle it today instead of tomorrow is the PSA that relates to it has a milestone for your order being entered today. The objection deadline, I believe, ran on the 23rd, maybe.
Okay.
And that contemplates one sale. I lost the copy of the order in the shuffle, but it's one sale to a PGM, which is a prudential affiliate.
Okay. Does anyone want to be heard with respect to that? Yes.
Thanks for not forgetting about us. Matthew Brooks, Your Honor, with Troutman Pepper on behalf of the buyer. We do have the order on file. We try to keep it relatively short for the court at 15 pages, I believe. But if Your Honor has any questions, I'm prepared to answer those for the buyer.
I doubt that I do. If it's consensual and nobody has objected, and I've got a declaration that supports it.
Yes, that's a docket 818.
Okay. And has that been uploaded? Okay. People will double check that it's been uploaded for me, then I will take a look at it. I wouldn't anticipate having any issues. I think I've signed all the previous orders without any changes. So as long as you didn't put anything unusual in it, then we're good.
I think you'll be fine.
But I will look at it this afternoon.
Thank you, Your Honor.
Okay. Anything else?
Your Honor, Jamie Fidel for the record. I would just note we do have the final financing order, but I believe the intention would be to defer that to tomorrow's hearing as well. Assuming,
okay.
Yes. Thank
Okay.
you.
Very good. One last chance. Okay. Thank you. We're adjourned. See you tomorrow.
Thank you.